Welcome to our webinar on recent changes in immigration policy impacting employers and employees. I am Laura Danielson, Fredrikson and Byron's Immigration Department Chair. We have a little housekeeping before we start. So the first thing is, for questions during this presentation, please hover over the bottom of your screen to see the Q&A feature. We will try to make room at the end for questions, and we're also happy to go over the allotted period of time to answer questions if we get a lot of them. The second thing is, during this presentation, if the internet audio cuts out, please use the dial-in number that's going to be provided. And here we are. So, we originally intended to talk about H1B professionals because we expected to see some significant changes by now. But that hasn't really happened yet. So we decided to revamp our program as so much has happened in the form of executive actions. As a reminder, the executive cannot change our immigration laws, but can implement policy. And the President historically does have a great deal of latitude in the immigration arena. So this webinar focuses on how recent policy changes impact employers and their foreign employees in the United States. So first, on January 27th, President Trump announced a travel ban that impacted nationals of 7 Muslim countries. This caught people off guard and resulted in chaos at airports and throughout the nation. And this ban was quickly blocked in federal court by multiple federal courts, actually. A few weeks later, on February 20th, the Secretary of Department of Homeland Security, John Kelly, released a couple of memos that implemented President Trump's previously issued executive orders on internal and border security, as well as on enforcement. And Huynh is going to discuss how these memos are going to impact employers and employees. Then, a week ago last Friday, we got word that there's going to be no premium processing for H1B employees after April 3rd. Debra Schneider is going to be discussing the impacts of this, as well as what is happening with H1Bs in general. And we're starting with her presentation because we promised you initially a talk about H1Bs, so we're going to start with that. Then, last Monday, March 6th, the President issued a new travel ban which overrides and really attempts to fix the faults of the previous one. It's 4 times longer than the previous one in the effort to do that. And I will be discussing this along with a memo that was issued the same day regarding heightened screening of all immigration applications. So so the question is, are there any limits on the administration's authority to make these policy changes? We do still have 3 branches of government in the United States after all. Bob Aronson is going to discuss the limits on executive power and various court challenges to these executive orders, as well as potential legislative initiatives that may well be coming down the pike. So take it away, Debra.
Hi there, good afternoon. So what I thought is most relevant for our H-1B visas is to understand what the law currently states today and what proposals we have seen come in place to revise or reform the H-1B program as we know it. The first regulation that has come out actually happened prior to the exiting of the Obama administration, and this is called the High Skilled Worker Final Rule. And this regulation codified much of policy rules that had been in place for the last decade or so by finally implementing regulations, so we have now a governing framework for most of the employment law process. I have focused on three main elements that address the H-1B program that would be most pertinent to your employees. First is the subject of portability. Portability came under AC 21, and it permits H-1B non-immigrants who are the beneficiaries of new H-1B petitions who are filing for an amendment or an extension of stay to begin a new or concurrent H-1B employment upon the filing of a non-frivolous H-1B petition. The new regulations limit portability from individuals who are already in H-1B status and continuing to be in H-1B status. This means you have to be in H-1B status to benefit from portability. The regulations also allow for successive H-1Bs, which means filing one on top of the other, provided that each is eventually approved. This provision is more important than ever after April 3rd, when the USCIS will no longer accept premium processing to expedite the decision of an H-1B. I'll discuss how this new issue in a moment. Another area that we could look at is called grace periods. Prior to this regulation, there were no grace periods ever written in regulations for H-1B workers. The new rules provide for a 10-day grace period before and after H-1B status. The regulations give permission for 10 days before a start date for the H-1B worker to be admitted into the country and a 10-day grace period to leave the country or change status after the period of stay ends. This 10-day grace period is not limited to only H-1B workers, but also applies to those in E, L, and TN status. In addition, the agency created a 60-day grace period for H-1B beneficiaries whose employment ends early. This also includes their dependents. This means if an H-1B worker's employment ends prior to the normal expiration of status, the beneficiary can receive up to 60 days of authorized stay, but not work authorized stay, to remain in the United States to change status, change employers, or depart the U.S. Finally, the other large rule that came into the regulation is for defining cap exemption. This had previously been decided by a range of different policy memos, which were into play until regulations were passed. And what cap exemption is, this prevents an employer from using the dreaded H-1B lottery. It is very limited, and in order to be considered a cap-exempt employer, you must meet one of the following definitions. 1, this is the easiest one to meet, you're an institute of higher education. This means if you're a university, you are cap-exempt. Second, if the employer is related or affiliated nonprofit entity that satisfies one of the following conditions, you too could be considered a cap-exempt employer. First, if you're a nonprofit entity that's connected or associated with an institute of higher education through shared ownership or control by the same board or federation. Second, or the nonprofit is operated by the university, or the nonprofit is attached to a university as a member, branch, cooperative, or a subsidiary, or more likely, most employers will fall under this provision, that you are a nonprofit that has entered into a formal written, and I stress written because this is new, affiliation agreement with the Institute of Higher Education, such as a university, that establishes an active working relationship with the Institute of Higher Education for the purposes of research or education, and a fundamental activity of the nonprofit is to directly contribute to the research or education mission of the Institute of Higher Education. What this means, if you're a nonprofit, research hospital, or potentially a school, if you have a written formal affiliation agreement with a university, and we can establish that the fundamental activity of your work directly contributes to the mission of the university, you may be able to qualify for cap exemption. What the regulations did, however, is eliminated the previously honoring of cap exemptions. So from the previous 2011 memo, if you had been considered a cap-exempt employer, you got to be grandfathered in. The new regulation has done away with grandfathering, so now all employers requesting cap exemption have to prove that they meet one of these requirements. This is going to now require additional documentation and evidence, but we hope it will be a more liberal interpretation. Prior to the implementation of this rule, USCIS had become making a narrower and narrower exemption for those who would be considered CAP exempt. So for those who do not qualify into a CAP exemption, you are going to be working with us, probably crazily, as we file for our April 1st CAP filing deadline. April 1st is the 6 months before the start of the government's fiscal year, which always begins on October 1st. Under current regulations, you're allowed to file up to 6 months in advance of the start date of October 1st, the first day visa numbers are released for new H-1Bs in the government fiscal year. That means every employer will be filing in the first 5 days in April. This year, April 1st lands on a Saturday, so the actual first date that the Immigration Service will accept H-1Bs under the CAP is Monday, April 3rd. As in years past, if the government receives more than the 65,000 regular CAP and 20,000 U.S. Masters CAP cases, it will run a lottery to determine which cases are lucky enough to be adjudicated. Those that are not chosen in the random lottery are returned as unselected. Those that are receipted in will have their filing fees taken and cases adjudicated. The big question is, when will we be notified? No one knows as of yet, but based upon past year and prior experience, we expect notification by May and potentially into June. In the past, those who had premium process usually received the receipt notices first and found out if they had been in the lottery. This year is going to be more egalitarian. Everyone will suffer under the same system. Premium processing was the biggest news that happened about 2 weeks ago, where USCIS had declared that all H-1B filings received on April 3rd and continuing for up to 6 months will no longer be allowed to file with premium processing. So you may ask, what is premium processing? It's what I've always called a bribery fee. It's a $1,225 fee that provides for adjudication of petitions in 15 calendar days. The suspension of premium processing means all cases will be under the same processing time. At present, H-1B petitions are taking nearly 6 to 9 months for adjudication. USCIS claims that eliminating premium processing will free up time and provide for better overall processing. Personally, I find that hard to believe. Immigration processing is funded by user fees. If you eliminate this premium processing fee, that means less funding for the government, which presumably means less money for more adjudicators. It also means the government has no deadline to adjudicate cases. There is now uncertainty in how long it will take until a final decision is reached on H-1B petitions. Not only is this painful for CAP cases, where thousands of employees' future will remain unknown for months until the H is decided, it also impacts all current H-1B workers. Essentially, by eliminating premium processing in tandem with a 6 to 9 month backlog in adjudications, H-1B workers and their employers are going to face a variety of harms. It could impact a travel impact on employees, essentially indirectly creating a new travel ban for thousands of H-1B employees who may have an H-1B extended, but if their initial H-1B has expired, the employee cannot secure a new H-1B visa to return to the United States. This can also impact H-1B workers in many states whose driver's licenses are tied to approvals and cannot be extended merely by the showing of a receipt notice. Fortunately, in Minnesota at least, employees can receive a temporary extension on their driver's license by presenting a receipt notice. However, not every state will accept this rule. States are also going to need to take some action to provide for an exemption. Additional concerns to think about are H-1B transfers. Portability is more important than ever, as otherwise it would be impossible for the new hire to begin employment until the H-1B improved, as that could take 6 to 9 months. For new hires who are changing status to an H-1B status, they will not be able to start working until the H-1B is approved. This will impact CAP-exempt employers hiring university professors, J-1 doctors, individuals changing from TN to H-1B status, from Q1 to H-1B teachers. It has a large variety of impact. Moreover, anyone outside the U.S. needing an H-1B visa who does not yet have an H-1B approval cannot enter the U.S. This can also impact the H-4 worker who are working under employment authorization document, as until the H-1B is approved, the H-4 cannot be approved and an EAD cannot be extended. USCIS has given very limited basis for requesting expedited processing. They've said on a case-by-case basis they will visit the extension if you can show an urgent need. Normally this has been very narrowly defined to severe financial loss, emergency situations, or humanitarian reasons. This is really the first long-term suspension of the premium processing program we have seen since it was first introduced in 2001. The repercussions will impact all H-1B employers. Hopefully, immigration will be true to its word and current adjudication will go back to the old processing of 3 to 4 months. Until then, note this will greatly impact your workers and your current workers and those seeking a CAP H-1B. I'll now turn to a few proposed changes. The first thing I want to state is none of these are the law, but there have been 3 recent bills proposed in both the House and the Senate, and really the most important part are the similarities with what these bills aim to address, because that is likely what we're going to see if some legislation actually passed. You can tell what's going to happen in these by looking at the title. The Protect and Grow American Jobs Act obviously is not aimed at enhancing the H-1B program and adding foreign workers. This was issued by Darrell Issa, which basically sought to redefine what an exempt H-1B non-immigrant is and eliminate the master's or higher degree requirement and raise the annual salary. Essentially what this is saying is for those who are dependent H-1B employers, and those would be employers who have a majority of the workforce using H-1B workers, would now have to pay higher fees for H-1B workers. This is the same thing we're going to see in the HR 170, the S180, and the HR 670. The bill that has drawn probably the most issues are both the Grassley bill and the Zoe Lofgren bill. The Grassley bill, which was introduced in the Senate, which is actually very similar to the same bill introduced 10 years ago in 2007, seeks to increase enforcement, modify wage requirements, and again protect American workers. How the Grassley bill proposes to do so is to do an internet posting requirement for 30 days advertising the job. It also seeks to prioritize who gets H-1Bs, giving the benefit to those who have graduated from U.S. universities, have advanced degrees, and have the highest wages. It's also sought to prohibit companies who have with more than 50 employees, or over half the workforce is on H&Ls, by preventing them from sponsoring any additional H-1B or L workers. The goal is have a market-based H-1B, prove that you can't find U.S. workers before they're allowing you to hire H-1B workers. What are the chances of this passing? In my opinion, it's going to depend on a larger immigration reform taken over by most employment-based visas. Finally, what scared the India Times and CNN was the Zoe Lofgren bill, which increased the annual wage for dependent employers by the magic number everyone's heard is $130,000. Now this was misreported, where everyone has started assuming that all H-1B workers needed to be paid $130,000. To clarify, that is not the rule. But what it did is provide a baseline rule for dependent employers, the target IT consulting companies. For better or for worse, all of these bills are aimed at targeting consulting companies who do use a majority of the CAP subject H-1B petitions. Without a doubt in my mind, when there's going to be reform for H-1Bs, the consulting industry is going to take a huge hit. If H-1B workers are important to your business, it's going to be important to let Congress know why you hire H-1B workers. Don't let the reforms used to erode one of the few means we have in our country to add professional, high-skilled workers to U.S. businesses. I will now turn to Lon Huynh, who will address the executive orders and the vast implications it is having nationwide.
Good afternoon, everyone. I'm going to be speaking about the executive orders that were released actually the same day that the first travel ban was announced on January 25th. And they were overshadowed as a result of the announcement of the first travel ban, which Laura is going to be speaking later on about this version 2 of this travel ban, which was released on March 6th. These 2 executive orders will have broader consequences on individuals who are living in the United States. And they are focused on border security and immigration enforcement, and also interior enforcement of immigration laws for individuals living in the United States. I'm going to first discuss the executive order regarding border security and immigration enforcement. I apologize, I have a little cough, so you may hear some coughing throughout the presentation, but I am fine. It's just a little catch in my throat sometimes. But on to the first executive order that I'm going to be discussing about border security and immigration enforcement. As the title reflects, the focus is on how the Trump administration will address the border, and this executive order, along with the implementing a memorandum that was released by DHS Secretary Kelly, Department of Homeland Security Secretary Kelly, also discussed about the popular border that we've heard about the administration's intent on constructing during the next 4 years. In addition to the construction of the border, the wall as we know it, though, it really addresses issues regarding the detention of individuals who are entering the U.S. and are found to be inadmissible or not possessing proper documents. And what this memorandum that was issued on February does is essentially orders the Department of Homeland Security, that includes the Immigration Custom Enforcement, but particularly Customs Border and Protection, in regards to its priorities when it comes to individuals who are entering the U.S. So previously, individuals who entered the U.S. And were caught because they did not have proper documentation or they were entering without inspection, they would be questioned, and if there were individuals or relatives that they had in the U.S., they could be bonded out and released pending a removal proceeding. What this order does, and also the memorandum, is state that individuals who are arriving aliens and found inadmissible should be detained and should not be released, what was previously known or called catch and release, where essentially if they had ties in the U.S. to individuals living in the U.S., they could be released. In addition, this memo also encourages states and local law enforcement entities to enter into agreements with the federal government, specifically DHS, to enforce federal immigration laws. So what we had after 9/11 was an increase in agreements between the federal government and local law enforcement entities to cooperate with each other and essentially deputize local law enforcement entities, police departments, to carry out immigration enforcement. And under this administration, we will again see an increase in these type of agreements between the federal government and local law enforcement entities. As you know, some cities have come out to say that they will not cooperate and they consider themselves sanctuary cities. And I think it's good to note which of those cities are sanctuary cities, because we definitely expect to see an increase in questioning by local law enforcement entities or local sheriff departments on an individual's immigration status in the United States. I want to note that these memos have just been recently released, and we may not see immediate consequences, but we expect that as the administration rolls out its policies and also its staffing in support of these memos, that there will be a change in how how the U.S. government is going to implement immigration laws. And I think the tenor will definitely be apparent as the days go on and the Trump administration starts establishing staffing and also instituting these policies among the various agencies. We have already seen a little of that in our interaction with the Immigration Service and even the Department of Labor and other entities when it comes to the implementation of immigration policies. Another aspect and a very disturbing element of this memo and the executive order is the expansion of expedited removal. Under expedited removal, the Department of Homeland Security can remove individuals from the U.S. at any time after apprehension without providing the individual opportunity to appear before immigration court or consult with legal counsel if they are within 100 miles of the U.S. border and in the U.S. for less than 14 days. Expedited removal exists at this time, but it's very limited. And what this memo does is it proposes or it allows the federal government to expand expedited removal to cover all of the U.S. And it also states that the Department of Homeland Security can implement expedited removal to those individuals who have been in the U.S. for less than 2 years and who are here without inspection, meaning they entered without inspection, or and they can be anywhere within the U.S. Before this provision is implemented, there needs to be notice in the Federal Register before they expand expedited removal. The concern that we have is the overzealous implementation of this provision, and also perhaps a misunderstanding of the provision itself by DHS officers who may be new to the field or view that this allows them power to question all individuals in the U.S., even those who may be here lawfully or entered with inspection. So we're really paying attention to this provision in light of how expansive it can be implemented and its misuse. All right, so the provision, another provision in the Border Security and Immigration Enforcement Executive Order and Memo is a provision that states that individuals who are found inadmissible and who are from a contiguous country such as Canada or Mexico, if they are found in the U.S. and they are found inadmissible, the Department of Homeland Security can return them to their to their country, even if they seek certain types of relief. For immigration relief in the United States. And essentially the idea of this provision is that the Trump administration would like to not have to detain these individuals in the U.S., send them back to their home country, and detain them in Mexico until they have their hearing, and the hearing can be via video conferencing. We're not quite sure how this is going to be implemented without the cooperation of other countries, but this is one of the provision proposed. Also, there is going to be a reevaluation of individuals who entered the United States as an unaccompanied minor. 2 years ago, about a year ago, there was a huge influx of individuals coming to the border from Central America and other South American countries where they were seeking protection from various acts of violence, or they were coming into the United States because of the situation in their home country. Many of these children were allowed in as unaccompanied minors and released to relatives, or they were detained if they did not have relatives in the United States. What this memo will do is allow the administration to reevaluate the status of these individuals to see if they still qualify as unaccompanied minor, which gives them certain immigration rights to hearings that are not before the immigration judge if they have an asylum hearing. And it also, a really disturbing part of the memo is it also encourages the Department of Homeland Security to enforce immigration laws against those who are believed to assist these individuals in entering the U.S. as an unaccompanied minor. And what that means is it allows the Immigration Service now to have broader discretion to enforce the immigration laws against parents or relatives who are believed to have paid traffickers or smugglers or assisted in any way the transport of these young minors into the U.S. Going on to other provisions in the memos that were issued, the second memo really addressed the enforcement of immigration law in the United States. Specifically, what are the enforcement priorities of the Department of Homeland Security? And as you can see, there's a whole list of enforcement priorities, but I want to focus specifically on the provisions relating to those who are charged with crimes, meaning individuals who have not been convicted with crimes but just charged may be placed in immigration proceedings. Those who committed criminal acts who may be charged with a criminal offense may also be placed in immigration proceedings and be an enforcement priority. And this is really disturbing because it questions or brings to question how the Department of Homeland Security is going to identify these individuals. And so we have concerns about racial profiling and an increase in it. It gives the federal government broader discretion as to what would constitute a criminal act. It's not a criminal offense yet, but perhaps their interpretation of the act may be very different from what is in our criminal laws. So there are other bases of enforcement priorities that will be a focus of the Immigration Service, as it really focuses on essentially a new policy of removing any individual who does not have legal status in the U.S. That is what this really comes down to in terms of the enforcement priorities, is the Trump administration's statement that if you are here without proper documents, or if you were here with proper documents and are currently out of status, you are vulnerable to being placed in removal proceedings, and there are no exceptions. I do want to note that a provision within this memo that's really important to what we call dreamers who have been granted deferred action as part of DACA will not be at this time part of the enforcement priorities. The Trump administration will be addressing this group of individuals at a later time, but the memo that sets out the enforcement priorities does recognize that the DACA provisions and the executive order that was released by President Obama, specifically in 2012, those provisions still remain, and this executive order and memorandum does not supplant it at this time. So what do these executive orders mean for employers and employees? As I've stated previously, we believe that these orders and memos really have broad consequences for a larger group of individuals than what we have been hearing in the news, specifically about the travel ban. And that's not in any way to diminish the travel ban, but these memos really empower DHS to enforce the immigration laws to its own discretion. And what this means for employers and employees is that it also adds a new tenor to the immigration adjudication of applications, but also to how the Immigration Service will treat individuals who are foreign nationals in the U.S. As such, it's really important that all employees who are currently in the U.S. working for a U.S. employer and they're on some type of non-immigrant status or visiting a company to interview, that they have proper documentation of their legal status in the U.S. Actually, under the law, all non-U.S. citizens should be prepared to present evidence of lawful immigration status at all times. And the Trump administration may decide that they will implement this specific provision because it does exist in the law that you are required to provide documentation of your legal status. Employers should also be very aware of when their non-immigrant employees' immigration status will be expiring and timely extend their immigration status. The possibility of being questioned as to an individual's immigration status will require them to have documentation that their status has been extended or they're currently in lawful status. Also, those who are non-immigrants traveling abroad should make sure that they possess the proper visa to re-enter and they are prepared for CBP to inspect them and question them. We can't take it for granted that they are able to come in because they have a valid visa. Employers need to make sure their employees are prepared as to the basis of their employment conditions, how much they're being paid, where they are working, and their duties that are required for them to be performed. And this information needs to be consistent with the applications that the employers have filed with the Immigration Service. Also, employees who are re-entering the United States, it's really important for them to make sure that they print out their I-94 electronic record evidence, which evidences their legal status in the U.S., and make sure that it is consistent with the validity of the non-immigrant petition for which they have been approved. We've seen many mistakes, and it would be a shame if someone had an I-94 card that they didn't realize expired earlier than their valid immigration petition. Companies should also establish protocols in response to immigration investigations as part of the higher scrutiny of non-immigrant petitions. We expect a higher number of visits from the federal fraud detention and national security investigators that are tasked with ensuring that individuals who are in the United States are employed in accordance with their non-immigrant petitions. But also something to really be cautious about is any representation that you make to the Immigration Service, whether it's in a form or verbally, needs to be truthful and consistent with all information that the employer has provided or the employee has provided. As I've mentioned before, we are in a new time when it comes to immigration enforcement. And although the Obama administration had the highest number of removals in the United States, the Trump administration is looking to also surpass that number of removals, but also really enforce the immigration law and ensure that those who are here are lawfully here with the proper documents too. So now, Laura, I think you're going to be discussing the executive order and specifically the travel ban.
Yeah, if your presentation wasn't depressing enough, Mon, now I'm going to talk briefly about the new travel ban, the new and improved version of the travel ban, which basically was announced on March 6th and which takes effect on March 16th. So rather than fight in court over the previous travel ban, which we also called, many people have called the Muslim ban, the administration decided to issue this improved travel ban on nationals from alleged terrorist countries that address a number of flaws in the previous ban. And this new version does the following. It forbids entry to nationals of 6 countries for at least 90 days. Those countries are Sudan, Syria, Somalia, Iran, Libya, and Yemen. Iraq has been omitted. So during these 90 days, there's going to be enhanced screening and vetting that will be undertaken. But also, this apparently requires cooperation from the governments of those 6 countries. And it isn't clear exactly what's going to happen after that 90-day period if those governments are not cooperative. It's likely the ban could be extended. Now, one thing that caused so much chaos is that, and this has been fixed, and that is that the ban no longer impacts green card holders or current valid visa holders who can still enter. It also doesn't impact third country nationals, which means people who are nationals of one of the 6 countries but also hold another passport. For example, a person born in Iran with a UK passport. Canadian landed immigrants are excluded as well, even if they are nationals of these 6 countries, meaning they have a passport from one of the 6 countries, but they've been granted the equivalence of permanent residence in Canada. Hardship waivers are available for things like family reunification, critical business needs, urgent medical care, and so forth. These are handled on a case-by-case basis, and we really don't know what the standard is going to be yet. There was a provision in the previous ban that favored certain minority religions, and that has been dropped. There still are significant limitations on refugee admissions, however, and while no longer an indefinite ban on Syrian refugees, all refugee admissions are halted for at least 120 days, except for those who are already processed for travel. Now, this is going to impact a lot of employees, and that is that overall, not just the 6 countries, but there's going to be no more revalidation of visas without interviews. It became sort of a common practice in certain consulates to allow frequent travelers to drop their passports off for new visas without interviews if they'd had a good past track record. And this has been done to avoid tremendous backlogs. And so since that practice has now been suspended, we would expect those backlogs to recur. There's an accompanying memo to the executive order that refers to a policy of heightened screening and vetting of applications for visas and all other immigration benefits, which presumably refers to USCIS adjudications, CBP entries, as well as to visa interviews. As you might imagine, these new policies are going to have a tremendous impact on travelers and others. First, even with a visa, employees from those 6 banned countries are likely to encounter heightened scrutiny. And once their visas expire, they're going to be stuck inside the U.S., unable to travel until or unless the situation is resolved. If they're stuck outside of the U.S. when it occurs, they're not going to be able to get back in. Also, travel, and we're getting a lot of questions about this, travel by those from other countries is likely to be impacted as well in a number of ways. First, we're hearing stories about Muslims from other countries, as well as many others, who are being pulled into secondary screening and questioned at length. Also, we expect backlogs to get worse, resulting in potential prolonged absences of employees while they wait for new visas. This extreme vetting policy, we're already seeing and hearing stories about heightened screening at all levels, from H1B and L adjudications to consular visa denials to denials at the border. Now I want to mention something. CBP has for years engaged in a practice of asking people in secondary inspection for passwords, not everybody, but those that they're investigating, so that they can see their emails and social media. Now, particularly if your employees are carrying sensitive company information or privileged communications with attorneys, these employees may want to consider clearing their devices or not carrying their devices during travel. And companies may want to even take a look at initiating some kind of policy in that regard. You may have heard that even U.S. citizens are being questioned. And so, all of us should at least take into consideration the possibility that our devices could be reviewed on entry to the United States. Of course, U.S. citizens can demand entry, but their devices can be held by CBP. And so finally, with regard to visa revalidations, without this drop box system for frequent travelers, I just want to emphasize we expect backlogs at certain consulates to get extreme. We're already hearing about visa interviews that are backlogged months at certain posts, and we just really can only expect that to continue unless these policies are turned around. Now, I hate to say it, but the bottom line of all of this is that employers and employees are going to really need to think carefully about how to navigate travel outside the U.S., at least for the immediate future, until we see how strictly these new policies are going to be implemented. So, Bob, tell us what we can do about all this.
Well, thanks, thanks very much, Laura. Over this past period of time, we've been talking about things that have been declared and what we think the implications are of various administration pronouncements in immigration. What I want to do is to take a peek ahead and to try to make some sense as to what to expect. And what I want to do initially is make three basic observations. First of all, historically and traditionally, Congress passes laws, the President implements that policy, and when it comes to immigration, the courts have largely been silent. There has been a movement over the years to for the courts to recognize certain rights among permanent residents, less so of non-immigrants, and traditionally the courts have been quite silent on individuals coming to the United States, and really defers to the President's authority to regulate the inspection and admission of foreign nationals, and to really recognize that the President has broad responsibilities for national security purposes that leads to certain executive policies relevant to the admission of foreign nationals. What we're seeing, though, and this is really a pronounced change, is that the courts are becoming more and more active in terms of looking at the essential fairness, looking at the underlying reasons for various administrative actions. And so when we're taking a look into the future, thus far we've been very focused on what has the President been doing through a series of executive orders, to which the courts thus far have been pushing back, and even the most recently announced executive order of March 6th is now undergoing certain judicial inspection and judicial review. So I think it's a misnomer to think that the future face of immigration is solely going to be determined by the administration, or even solely by the administration in conjunction with the Congress, that there's a very powerful movement within the judiciary, within the courts, to ameliorate, to ensure that there are certain basic elements of fair play and advance notice as to who is coming into the United States. And in particular, to ensure that certain foreign nationals, particularly based on religious grounds or ethnic or racial, are not being excluded. That's my point number one, that there's going to be a much more heavily contextualized system in place. Number two, when it comes to employment-based immigration, I think there's a real tension going on in the administration. And here's what I mean. During the campaign, President Trump made certain pronouncements in terms of the H1B being a job giveaway program, kind of painting himself into a certain box in terms of how he is defining employment-based immigration. And yet he's declared that his administration is highly supportive of initiatives to grow the U.S. economy. He's announced a 3% growth of the economy as being something he wants to see. He will not be able to reach that goal without the active involvement of foreign nationals. So what I think there is conceivably a tension between a certain ideological or certain campaign-driven pronouncements with the reality of what foreign nationals bring to the table in terms of economic growth. Number three, the only thing I want to further highlight is that thus far people have been very, and I think justifiably so, focused on immigration restriction. This is a recurrent situation within American history. That is, that there have been periods of constriction, there have been periods of reanalysis, and there have been periods of liberalization. So what I do want to say is that despite the initial onslaught of certain constrictive elements, the U.S. immigration system remains largely in effect, and that the basic utilization of our immigration system by employers as well as foreign nationals remain to a large extent still in existence. Now, I think that there are going to be three areas of focus, though, that the administration is going to be looking at, or that we can see in the future. Number one, certain limits of executive control. How far can the executive go without running into pushback from Congress, without running into pushback from the judiciary? Number one. Number two, what are some of the employment-based initiatives that we very well may see coming down the pike? And number three, there's been a great deal of interest over the past years, and this dates back for several generations, in terms of re-examining our whole immigration system and trying to develop immigration policies that will ensure our company's competitiveness in a global economy, that will ensure that we are adopting our immigration laws to current realities. And it seems to me that these are the three areas of focus that we can expect moving forward. So what are the limits of executive control? What is going to be on the table? First of all, there's, and Lon had addressed this briefly, the Dreamers, the Deferred Action Program, for those children who came to the United States not through their own decision-making process, but rather as part of a larger family unit. So far, and this is obviously a huge segment of individuals who technically are here without authorization, and yet because of the equities of the situation, because of their contributions to the United States, they've been granted so far, not legislatively, but they've been granted a tentative, uncertain, unstable legal situation, allowing them to normalize their lives to a certain extent in the United States. So far, the Dreamers are not being subjected to a withdrawal of their Dreamer status. And at least some of the statements from the President indicate his recognition of ensuring that they continue to have a role within American society, a role within the country. Again, that can change, but so far the Dreamers have been stabilized. What is considerably less certain, and this goes to a general movement in terms of really invigorating the removal or deportation system, is the degree to which the government will look to equities and kind of balance out the family reunification issues in terms of providing immigration status, particularly to parents of Dreamers. That is, will the United States continue to have kind of an unyielding removal system that is, once you come in without authorization, that the only solution is eviction through the removal process? Or will there be a much more nuanced weighing of contributions of individuals, of family ties, of all of that? And my my expectation is that this element will probably not be decided solely within the administration and solely, but rather that it may very well be part of an overall movement toward immigration reform. And that leads to kind of the third and final basic statement, which is that, you know, the United States has traditionally looked to due process and fair play in terms of our immigration system. Let's take a look at an individual's equities in the United States, their contributions, their record of achievement, and so on, and to try to create some type of solution set. And that's, I think, what we're going to be seeing. Again, I think it's going to be lumped in with a congressional review, presumably and hopefully with some administration leadership into overall immigration reform. Okay, now taking a look at employment. There are a couple elements that I think we might see initially probably coming out of the administration and very possibly going through congressional review. And Debra referred to some of these things, but here's what I really think is going to happen. I think that we're going to be seeing a tilt, a reorientation in the U.S. immigration system away from family-based immigration into employment-based immigration. And I say this in large measure because the President is a product of the business community. I very firmly believe that we're going to see expansions for high-skilled workers. That is, STEM workers, individuals with advanced degrees. That, you know, we've seen some major movements in terms of expanding a type of filing for permanent residence for individuals contributing to the national interest. There's been some discussion about recognizing STEM workers, particularly those with advanced degrees, as having either an automatic route to permanent residence or a highly expedited route. And my very firm belief is that we're going to continue to see liberalizations coming down in terms of high-skilled workers, thought leaders, particularly in the STEM disciplines, that is science, technology, engineering, and math, who by their nature and existence can contribute substantially to the United States. In terms of H1B reform, that's really a very hard nut to crack. I think we are going to see, and I think Debra had mentioned this, certain carve-outs and probably restrictions related to the IT industry, particularly the job shops, because it's become kind of a political football. But at the same time, I think that there's a major possibility that we're going to start to see some movement to increase the H-1B numbers, because again, the demand for the numbers has so greatly exceeded the supply that we've gotten into this terribly self-defeating situation of meritorious H-1B cases becoming subject to the whims of a lottery. I think we're also going to see a rationalization of how lottery numbers get distributed. That is, allocations and being made to advanced degree foreign nationals, particularly those in the STEM disciplines. Those also probably with high salaries. But in other words, not to use the lottery system simply based on luck of the draw, but to try to create some type of predictable outcome to lottery candidates. The one thing that is very much on the drawing board, and this does rest on, in large measure, on the President's decision, is the right of H-4 spouses to hold employment authorization. Right now, this is under review by the administration. The H-4 employment authorization possibility dates back, it's fairly new, it dates back to 2015, and it is a function not of congressional action but of administrative initiative. And I also think that when all of the dust settles, we will continue to see a very robust opportunity for international students coming to the United States, including those, and particularly those involved in STEM programs, and providing them with abilities to hold STEM OPT, which is a 2-year grant of extension. In terms of the overriding issue of immigration reform, what are some of the issues that might come up for consideration? And again, this would be something that would require congressional action in conjunction, presumably, with administrative leadership from the administration. As I mentioned, I think we're going to see a reallocation of immigration numbers, very possibly from the family quota into the employment. And I would not be surprised if we don't see an increase in the worldwide employment numbers. Right now, there are backlogs, particularly for India and China, in the second preference. It gets worse in the third preference. And given all of the data indicating that foreign nationals, through legal immigration, create significant benefits to the United States, I wouldn't be surprised if we don't see increases in the worldwide employment numbers. There's also talk about instituting new architectures in terms of who can come into the United States. Perhaps that would be a point system, or perhaps it would be through recognition of different criteria as to indicating who can best contribute to the United States. And also, right now, because of a provision in the law that limits to 7% the number of immigrants who can come in from any one country, there's miserable backlogs in India and China in the employment arena. I think that we may see some version of either a universal or targeted relief to clear up these backlogs.
Well, it's always good to end on a more hopeful note. I do believe a lot of people are going to get hurt until we get to that point of new legislation or court changes to these new policies, and I worry a lot about how these policies will chill the desire of these highly skilled people to study or work in the U.S. in the future. So for those of you who are listening, if you can let your congressional representatives know what your feelings are about this and how this may impact your business, I think that's going to be very important. We did receive a few questions in the process of giving this talk, and I've been following along and really do believe that all of these questions have been answered as part of our presentations. So unless, Bob, did you get one that hasn't been answered?
I have one. It's specifically targeted or deals with J1 physicians, and because of its specificity, I'd be very happy to receive a direct communication from the requester.
Okay, great. Otherwise, I think that your questions have been answered, but I want to emphasize that we're here, we're available, we're happy to answer any of your questions or concerns. We know this is just an extremely stressful, difficult time. We know that people want to visit family, you know, go forward with weddings, you know, deal with all the many things that life brings, and this may present obstacles to some of you, and we'll do all we can to help. Thank you very much.